I'd like to welcome you specially to our online educational series. Today is going to be Law of Contract, and we are beginning from the scratch. Once again, my name is Emperor Kemjika Naoma. I am a lecturer with Clifford University, Abia State. I welcome you to my channel, The Legal Playlist. Now, in everyday life, people do a lot of transactional activities, economic activities. There is no blessed day anybody in the face of the world will not buy or sell. They will either buy goods, they will either buy services, they will either sell goods, they will either sell services. Under the goods to be sold, houses might be there, properties might be there. When you talk about properties, it could be houses, it could also be land, it could be cars, it could be shirts, it could be shoes, anything that has the capacity or the quality of being sold is attributed or comes under the tag goods. And then when you talk about services, services are not actually what ordinarily speaking can be sold or bought, but then services can actually be hired. Services can actually be retained. And so, for instance, if I am a tiler and I specialize in tiling people's houses, my services can actually be bought if I am contracted to tile people's houses. So, because people engage in one transaction or the other every other day, and as human beings, human beings are susceptible to a lot of things. We are fraught with a lot of things. Number one, human beings can disappoint fellow human beings, all right? You can wake up tomorrow, you have agreed with somebody to go into a particular partnership, into a particular business, and the person of a sudden will just like, no, that was not what I meant. Oh, I did not agree with you. You can actually go into an agreement with someone, and the person will be like, oh, my brother, something came up. Oh, I cannot continue. This story here, I lost my great grandmother's last born's daughter's son. They just cook up one reason somewhere to discontinue with that initial statement, that initial agreement, that initial understanding they have or they had with you. Because these are normal things that human beings are fraught with, the law came in to salvage the situation so that the understandings human beings have every day will no longer be treated just as an agreement that people can just break at any time. So the law came in to give human agreement a lifted status, and that's now from being a mere agreement to contract. That will now lead us to now talking about what contract actually is. Of course, anywhere you can say that a contract is a consensual relationship. It is an agreement. It is an understanding between two parties, all right, party A and party B, or a group of parties, all right, 1, 2, 3 persons under one group, 1, 2, 3, 4, 5 persons under another group. Contract is an agreement, is an understanding between two parties which carries legal reciprocal rights, obligations, and of course liabilities, which the court will enforce in the cases of breach, or which the court will also issue remedies in the cases of breach, or which the court will also uphold or enforce in the cases of performance. However it is, there are salient points to take away from that definition of contract as being the agreement between two parties which the court will always enforce if only they have the flavor of law. It means, for the first time, or firstly, that there needs to be the understanding between the two parties. So party A must have agreed with party B to go into a particular thing. Take, for instance, the person who sold this shirt for me, or who sold the material for me. I would have gone to the person, I said, I want to buy this material. The person will also say, okay, yes, I am selling. For me going to the person to buy and telling the person I want to buy, I have had the intention to buy the material. And for the person saying I am selling for XYZ amount, the person has also had the intention to sell for me. So there is agreement, mutual agreement. And in law, it is called consensus ad idem. That is meeting of the mind. The both parties have agreed to venture into a particular thing. So that is one thing you will take away from that definition. Another thing is that contract cannot exist except there are two parties to it. So one person cannot just wake up like myself and say, I want to have a contract with myself. It is not possible. I can't have a contract with myself. So that's another feature to look into it. Number 3 feature to draw from that definition of contract is that it is actually an understanding, an agreement that the court is always ready to enforce. in situations where breach arises. That is to say, party A and party B have agreed to do something, and one of them fails to do that particular thing he or she had agreed before. The law will now be invoked. The court will now be invoked by way of the other person who is aggrieved, who is angry, going to court to say, court, please, we agreed on this thing. So please, why I'm here is that you will help me tell this guy to do the same thing we had agreed to do. So the court will now tell the person who has breached the contract, who has offended that contract, who has failed to perform his own part of the contract, to do that same thing he ought to do. Now, at this stage, I'm not going to be telling you how the court or the ways through which the court will make that same person to do those things. It will come much later, maybe under remedies and all of that. But we are at the preliminary stage of contract law. And so let us leave it at the basis. That leaves us to defining contract law. Having defined contract, what then is contract law? And why did I initially say that sometimes people mistake the two? You have to understand that the first one is the agreement between two parties. And then the second one has to do with contract law, meaning that there is a contract and there is a law. It means that the law standing side by side with contract is or are, that is where it has to do with more than one law, or the body of laws, legal regimes, instruments, all right, that regulates, that governs, that stipulates, that oversees the affairs of parties' agreement. So, contract law is that aspect of the law, or is a body of law, or a body of laws that comes under the responsibility of regulating and governing the contractual activities between two parties. The law of contract will lie on the bed and will be sleeping until something provokes it to happen. That is to say, parties, when they have entered into agreement, until one party does something that is not in line, that is not in tandem with the law, that is when the law will now wake up. That is where you now see that it is actually the law that regulates the contract that takes place between parties. That is how you now see the difference between contracts and contract law. Very quickly, we'll be delving into the purpose or the significance of contract and the significance of contract law. I am going to map up the two of them together simultaneously. From the definition, you can already deduce the significance, the importance, the values of contract and contract law. Number one is that both contract and contract law establishes the rights of parties to the agreement. That is to say, if myself and another party enters into an agreement, let's say I want to buy a plot of land. I am the purchaser. The person who wants to sell the land to me, the owner of the land, is the vendor. It has established my rights, all right, in section 43 of the Constitution, we say I have the right to acquire immovable property anywhere. So I have the right to buy. And the person implicit in that section has the right to sell. So contract and contract law creates or establishes reciprocal rights. In the same spirit, another significance of contract law is that it also creates or establishes reciprocal liabilities. That is to say, if there is anything I fail to do in the course of that contract, I will face the consequences. I will face the stipulations of the law. I will face, whatever punishment the law will meet on me, and will become a remedy to the other person. That is one thing. The third thing there is that contract law enforces the rights of parties to contract. That is to say, when one party has offended, the law we veto its power. The law will apply its power against that party that actually profaned or breached the tenets of contract. These and many more, of course, are the reasons why contract and contract law is very significant. Of course, the course contract law is very focal, it's very central, it's very germane to human activities. There is hardly anything you do in your life every day that contractual flavor does not come in. Whether you go to buy something, whether you go to work for somebody, whether you go to school, that is just a flavor of contract. Whether you go to hospital, whether you go to the amusement park. This is now going to bring us to the next stage of our lesson today, which is talking about where is contract law applied. Of course, in between or along the line of this video, we have even mention the areas contract law can apply. As you wake up in the morning, you want to go to work, you just stand by the road, you flag down a vehicle, all right, and you enter, and you say, maybe, are you going to, let's say, my three? The boss say, yes, I'm going to my three. You enter. Contract has taken place. What is the contract there? The fact that you are going to pay the driver at the end of the day, and what the driver has to do for you as a duty is to pick you from the point where you enter the vehicle to my tree and drop you off. The driver would have fulfilled his obligation, and you pay the fare. That is contract. You don't need to, begin to write it down in paper. Contract has taken place. As we move on, you will understand under which form this kind of contract can actually take place. If you go to the cinema, you want to see a movie, you buy your ticket. From the moment you bought your ticket of wanting to go and see a particular movie, you have paid the money. That money you paid is your own consideration. All right. So you are expected to see the particular movie which made you go to cinema. If at the end of the day, the people who is in charge do not play the particular movie that made you to pay for that ticket, we would say that they are in breach of the agreement you would have had with them. So contract applies in everything we do. How about in the school system? All right. So from the time you gain admission, the school has assured you that you are going to learn all the courses that applies to your area of profession, and they are giving you nothing shortfall of the quality, the standard, base of teaching and class as the world international best practices would have. So if they fail in any way to give you the best quality of education, they would have been failing in their own bargain in this contract between a school and, of course, the student. It is also contractual that when you are the landlord of a particular house and somebody is your tenant, the person is expected to pay rent every year or every quarter or every month, depending on the kind of tenancy that runs between you and the person. So you see, we can go on and on and on to say that contract applies in a lot of areas: in the law of agency, in the law of insurance, in the law of health, in the law of business. There are a whole lot of areas where contract applies, just to mention but a few. While winding up this series of our education today, we're going to be talking about, at this stage now, the forms of contracts. The forms of contract. By the way, at this point, if you're just joining this class, I'm still reminding you, do not fail to subscribe to my channel, the Legal Playlist. Please hit the subscribe button or the subscription button, and please turn on the notification bell by the side, and then click all, so that you will always get our video content each time we post. And of course, if you're getting value from this teaching, do well to make comments at the comment section. Talk about what you've understood, maybe something that is not clear to you. Ask questions that will prompt further teachings, and we'll still come back to teach more, to make sure you understand everything there is to be understood at the preliminary stage of contract law. Forms of contract. Under the common law regime, there are basically two forms of contract. All right, under the common law, there are basically two forms of contract. We have formal contract, we have informal contract. That formal contract can also be referred to as contract under seal. That informal contract can also be referred to as a parole contract, an oral contract, or a simple contract. I take a pause here very quickly to now say that there are cases that apply to all the things we have said earlier from the beginning till now. You can look at the case of Robinet Nigerian Limited and Shell Nigerian Gas Limited. Yes, Robinet Nigerian Limited and Shell Nigerian Gas Limited. You can also look at the case of Jegede and Major Engineering Company Limited. These two cases, are key to talk about all that we have said earlier. They are authorities in these areas. All right, so let's talk about the forms of contract. We've talked about formal contract, which is also referred to as contract under seal or a written contract. And then we have informal contract, which is also referred to as a parole contract or oral contract or simple contract. Make no mistake, under them we still have other forms of contract, of course, like the bilateral contract, the unilateral contract, the express contract, and of course the implied contract. When can we say a contract is formal? A formal contract is that kind of contract, is that species of contract, is that form of contract that derives validity from its form and its form alone. What it means is that a formal contract has specificities. A formal contract has ways it is identified. That is to say, if you enter into a particular kind of contract, yeah. So when that contract takes that shape, nobody needs to tell you that that contract is a formal contract. So what are the features of a formal contract? Number one, a formal contract is that kind of contract that must be written down, either with pen on a paper or typed as a document. So one of its form of features is that it must be documented. That's one of the forms of a formal contract. The number two form of a formal contract is that that contract must be sealed. The contract must be sealed. And then number three feature is that in place of seal, that contract must be signed. Then the last feature of a formal contract is that the contract must be delivered. So as a law student or as a lawyer, you would have heard most times or oftentimes when people say signed, sealed, and delivered. Signed, sealed, and delivered. Any contract that takes this form is a formal contract. Of course, you cannot sign or seal a contract that is not written down somewhere. So there must be something, whether a scroll, whether a parchment, whether a document, in any form that a contract is reduced. So there are contracts that, of course, must, in any way you look at it, be written down. As we go on with this video, you will understand those kind of contracts. All right, the next form of contract to be talked about is the informal contract, which is also referred to as the parole contract or oral contract or simple contract. Now, this kind of contract is not expected to be in writing. That is to say, the informal contract is an oral kind of contract. It's a verbal kind of contract. It's a contract that must not be written down on a paper, except in situations where the law requires that those kind of contract be written down because of the nature. Yes, it can be a simple contract, it can be an informal contract, but the laws that promote them, the laws that back them up, provides that they should be written down. For instance, you look at section 2 sub 2 sub paragraph 9 of the Hire Purchase Act. That law requires that the memorandum of understanding between the hirer must be written down and signed, even if it is an informal contract, even if it is a simple contract. Another area to also look at is when there is a contract of sale of land. The law requires that it must be written down, and there is just one reason why this kind of contract must be written down or should be written down. It is for the purposes of precision, because properties are involved in this, in this kind of contract now. So the law requires that they be written down for the purposes of precision, so that there will not be ambiguity, there will not be vagueness of terms. The law requires that everything be clearly spelled out. That is the reason why this contract must be written down. And so they may not necessarily need to take the forms of the formal contract, that is to say, signed, sealed, and delivered. Now let me talk about signed, sealed, and delivered very briefly. Before the 19th and 20th century, formal contracts are usually sealed by a red wafer. I wouldn't know, you should have seen maybe in some legal document a very small round red parchment that is just plastered or affixed over the document against somebody's name, where the person will now sign on top. That thing is referred to as a red wafer. It is one of the things that is used to authenticate formal documents or formal contract documents before the 19th and 20th century, until when it is discovered that the thing now became so common, we had proliferation of the production of wafer, and so the law had to move away from the use of wafer alone to seal a document, to recognizing the significance and the authenticity of having signatures of parties to the contract to the document of the contract. Another thing is delivery. We talked about sign, seal, and delivery. There are two ways that delivery can actually take place as far as any form of contract is concerned. Number one is physical or actual delivery, where the person who has executed the contract will take the contract document and hand over to the next party, all right, after affixing his stamp and seal or signature. That is actual or physical delivery. There is another one which is referred to as a constructive delivery. The executor of that contract might not actually deliver the document to the other party, but there is a clause attached in the contract document which talks about the intention. It is called an operative clause, which talks about the intention of parties to be bound by the terms of the contract, such that even if the contract document remains in the possession of either of the parties, because of the presence of that operative clause in there, the contract is deemed to have been delivered. Very quickly, we just go over to bilateral contract. Of course, when you hear the word bilateral, two things come to mind. There is a fusion of two words, bi, and lateral. So it suggests, of course, bi has to do with something that has to do with more than one. So bilateral contract is a contract that is formed by more than one person, two persons, or more parties, a group of parties, or a group of people in one party, a group of people again in another party. So bilateral contract is that form of contract that exists between parties, not just one person. All right, that contract is a bilateral contract. Of course, somebody want to buy a land, you cannot buy your own land, you have to buy another person's land. So you, the purchaser, the other person, the vendor, come together to form bilateral contract or to enter into bilateral contract. Very quickly, let us look at the next contract, unilateral contract. I so much love this kind of contract. Now, it is the direct opposite of bilateral contract. A unilateral contract is a contract that is ventured into by just one person as a party, and the other party is the whole world. That is to say, the next party the person should expect in that contract is not known. All right. When you want to look up cases in under bilateral contract, look at the case of Damina and Akman. You look at the case of Sherivor and Tripolis Motors Limited. You look at the case of Robinet Nigerian Limited, and of course Shell Nigerian Gas Limited, and all those other cases. Okay, you look at the case of Evans and Yoris Tor Limited. Many of those beautiful cases are the case of Talk and Moxie. But when it has to do with a unilateral contract, it is that kind of contract that one person starts, one person, goes into with the whole world. Now the question is, can one person actually go into a contract with the whole world? Let us see whether the law answers it yes or no. For me, I would say yes. And there is a locus classicus case in it, the case of Khalil and Carbolic Smoke Ball. You remember that case? Yeah. When the company Carbolic Smoke Ball produced a smoke ball that should ordinarily cure influenza, and they said anybody who uses this smoke ball based on the specifications that we have given for the period of 8 weeks and still catches influenza, 1,000 pounds have been reserved in a bank. We will give the person. So anytime somebody makes a statement, of course in Nigeria here oftentimes you will see where EFCC say we are looking for XYZ person. Any person who gives us information to the whereabouts of that person, we are giving the person 20 million naira. So that kind of contract, EFCC is the primary party, and EFCC has made that contract with anybody who will do that same thing that EFCC requires to be done. The law provides that from the commencement of the performance of that contract, all right, the other person has already identified himself, and that contract becomes binding on the first person who made that promise. Let me draw an instance. For instance, maybe an air conditioner of a certain police officer went missing, and nobody knew who took away the air conditioner. All investigation had proved abortive, and the police officer loved the air conditioner so much that he said, anybody who is able to identify or give us information that will lead to the person who stole this air conditioner, we will give the person 150 million naira, for instance. That's a lot of money anyways. And then the question is, the police officer has made a promise, right? And so any person who upon that promise acts and gets information that will lead to the whereabouts of the person who stole the police officer's air conditioner becomes the second party to that contract. You can look up very quickly the case of, like I said earlier, Kali and Carbonic Small Ball. You can also look up the case of O'Brien and MGN Limited. A very beautiful case there. O'Brien and MGN Limited. Somebody went to buy a newspaper, and in that newspaper, they said a certain other paper, Miro brand, is giving out £50,000 for anybody who scratches the card on each newspaper and wins. And then somebody picked up the newspaper, Miro brand, and bought it, scratched it, and of course won that raffles and called. And they say, yes, you are actually entitled to $50,000. Somehow the money was not paid. You went to court, and the court said from the moment the person took steps to go buy that newspaper, scratch it, made a call to you people, he had actually done what you wanted him to do. So that contract comes to be. Finally, we are going to look at the next form of contract, which is, of course, express contract. Express contract is a form of contract where all the terms of the contract are clearly, unambiguously stated in the contract. Okay, Tom and Jerry went into a contract. Tom, you are going to sweep my compound 2 times a day, and I will be paying you every Friday. It means that 7 days, Tom will be sweeping Jerry's compound 2 times a day for 7 days, and then Jerry will pay him every Friday. The terms of the contract are expressly, explicitly, all right, unambiguously stated on the face of the contract paper. That is when we can say that the contract is express. There is nothing to imply. There is nothing to say, I forgot this one, but since I said this one, you should have known now that I meant it. No, that would not fall under express contract. So take it home that an express contract is that form of contract that produces every terms and condition, every clause or clauses that are to be contained in that contract to be very clear and unambiguous. The direct opposite of express contract is going to bring us to implied contract, which of course will bring us to the end of our introductory part of contract law today. What is an implied contract? Just as the name suggests, for something to be implied means that thing is not express, means it is something that is acted out by conduct, an information that is passed by way of conduct. I did not say anything, but my body language will suggest to you that, I'm hungry. And so you bring me food. You're hungry. I'm bringing you food. It's called 2,500 naira. And you serve me. If I enter a restaurant, the general implication is that I want to eat. So either the waiter or the waitress will approach me with menu. So even if I did not ask for the menu for the restaurant, as far as I've entered the restaurant to sit down, few minutes or seconds down the line, the implication is that I want to eat. Imagine a student who maybe wanting to leave a faculty to maybe the up campus or the main campus gate, and then the person just got to the school park, enters a bus or a fare, a taxi, the university cab, which usually drives people to the main gate. Without telling the driver anything, the driver not asking any question, it is presumed that that student want to go to the main campus gate where he or she knows that that taxi, that cab is going to. And it is also implied that upon the driver taking the student to that particular place, that student has the obligation and responsibility to pay the fare, the amount of money that is required for having taken him or her to that place. That is what implied contract is. A kind of contract that the court will look at the body language. So it's a contract that holds on the substance of the terms and not just on the form of it, basically. That is an implied contract. Gentlemen, don't forget that today we just looked at the preliminary stage. It's a kind of introductory class to contract and contract law. Don't forget we define contract. Don't forget we said it's an agreement between two parties creating reciprocal rights, liabilities, duties, and obligations, which the court will enforce in cases of performance or breach of contract. And don't forget we said that contract law is all the aspect of laws, or the total body of laws that regulates, that governs, and that stipulates the do's and don'ts of a contract. Don't also forget that we talked about the forms of contract, and we said that there are two forms of contract under common law. We mentioned the formal contract, which is also referred to as contract under seal or a written contract. And then we talked about the informal contract, which is also referred to as the parole or oral or simple contract. Don't also forget that we talked about the bilateral contract, we talked about the unilateral contract, we talked about, of course, the express and the implied contract. Once again, thank you very much for listening and sticking by to the end of this video. I hope you got values. Please do hit us on the comment section or at the comment section with your questions on areas you're not clear. Be rest assured that we come back again to explain anything to you. My name is Emperor Kemjika Nauma. I am a legal practitioner and a lawyer with and a lecturer, beg your pardon, with Clifford University, Abia State. And once again, you are at my educational YouTube channel. The theme is the legal playlist. So when you play, you listen to legal content. Don't forget to subscribe to this channel, hit the notification bell, and please do well to like my videos so that the YouTube algorithm can actually push it to larger audience. God bless you and thank you. Until I meet you again, we're going to be talking about, of course, the elements of contract in our next series, which is going to have us talk about offer, acceptance, consideration, intention to create legal relation, counter offer, cross offer, and all of those beautiful elements of contract. Until I cross your way again, God bless you.